Hey guys, it looks like the judge in the Manson versus Wood Gore case has decided to delay the hearing on limited discovery in a tentative ruling. There's nothing to read into that. That could be the judge needs more time to read it. The judge has other things that are more pressing. The judge's car is broken down. She's not going to make it into court for a while. Whatever the reason, it's going to get rescheduled and heard again later. So that's the news on that. But I thought, since we're not going to have the news of what the judge is actually going to do, let's look at some of the issues which may remain complicated in this and could influence the judge's decision. And that's the scope of the discovery that Manson is requesting. He's asked for 5 depositions, the 2 defendants, and 3 non-party deponents. One is Agent Langer, who's in Florida, and Catherine McGaffigan, who's in New York, and Michelle Meyer, and I don't recall where she is, but that's not necessary for the points that we're going to go over. So the court could say, yes, I will allow this discovery of these 5 people. And the court could say, I'm not going to allow any discovery. Or the court could say, I think, depending on how the defendants argue, I'm going to allow the depositions of the defendants and not these other people who live in various parts around the country, Florida and New York. And the reason for that could be that one of the purposes of the anti-SLAPP motion is to prevent the defendants from having to go through a great deal of expense/harassment in a case that the plaintiff can't show the prima facie merit of early in the litigation. And having to set for a deposition yourself, especially if the case is going to continue past anti-SLAPP like it is in this case, it's hard to argue that that's but so much inconvenience, especially when the deposition is limited to the issues involved in the motion. But having to pay your attorneys to fly around to Florida and New York for these other depositions, that seems like a lot bigger situation, a lot bigger expense than just attending to your own deposition. You're having to travel and all these things, and maybe the judge may split the baby and say, listen, I'll give you the benefit of the doubt and let you make the case with the evidence you have and solicit information from the defendants. But if when you filed this lawsuit knowing that you might be subject to the anti-SLAPP motion, you were going to require information from across the entire continent of the United States in order just to get past this motion, no, we're not going to go that far. That's not limited discovery. It's limited in what you want to talk about, but it's unlimited in geography and expense for the defendants. So the judge may do that. Anyway, the point of this video will be what's involved in getting testimony from people who live in other states. And if you watched the Depp v. Heard case, a lot of people did, that he got this judgment for $10 million. Well, what can he do with it? Especially since the case is on appeal. And a lot of people thought, well, she has to file this suspension bond for $10 million, but she really didn't have to do that. But if she had done it or could have done it and did do it, that would have been great for Depp because some solvent entity would have posted a letter of credit or bond or whatever to the court in Virginia that when the appeal was settled and denied like it probably will be, Depp could, if he couldn't get the money from Heard, get it from the solvent entity that posted the bond. But she didn't post the suspension bond. She never had to. And that means if he wants the money, he's got to chase it wherever she may have it. And that involves taking your Virginia judgment, going around the country with it, trying to domesticate it wherever she may have assets. And that's also the situation when you want to depose people who are out of state. Because the California court cannot by itself order, say, a citizen and resident of Florida set for a deposition for a California case. It's a federal system. They don't have the power to do that. Just like California judgment isn't good in Florida until you go to Florida and get the Florida court to domesticate it. So there are procedures, and it happens that they've been modernized in the 2 states that I know of where these people are, and that's Florida and New York. Both those states have adopted statutes that streamline the process of taking a subpoena from your home court, say in California, taking it down to, say, Florida. You go to the county where you want the subpoena issued, and you're allowed to ask the court there to issue a subpoena for your action back in California. That doesn't count as an appearance in court, which you can't do if you're not licensed there. And that clerk will issue the subpoena to the person. So that's a pretty streamlined process. Better than I thought it might be until I looked up how the current statutes are. So you still have to do it. I mean, you got to go to that courthouse and you got to get this subpoena issued by the clerk, and then you serve it on the person who's going to be deposed. So that's not too bad. I'll show a couple of the statutes here about Florida, and the ones in New York are similar because it's kind of a model statute that many states have adopted. But there's another fly in the ointment. Nothing's ever completely easy in the law, right? Well, when they go down to Florida and not just there to enjoy the sun, but to depose Agent Langer. So they go through the streamlined process to issue this subpoena to Agent Langer. That's great. She's going to show up and she's going to tell us about this letter, right? No, you don't just sit in your law office and go, I think I'll just subpoena all FBI agents and get their information they gained in the course of their job. I'll be right back. Let me just go get their depositions. The federal government has rules in place, and of course, since they get to decide the rules, they decide how they work, that say you cannot subpoena an employee or even an ex-employee of the Department of Justice, other departments too, but here we're talking about the FBI, to provide information in a deposition in a state or federal proceeding until the department itself first approves that. Okay, that's the federal law. So if Agent Langer receives this subpoena, she's going to have to turn it over to the U.S. Attorney's Office and they'll deal with it. But in theory, Manson's attorneys first would ask the Department of Justice to allow her to set for deposition for the specified information they need. And the Department of Justice can resist that subpoena. And if they don't agree to produce her as a witness, she can't sit as a witness, and they'll have to go to court and fight over whether the Department of Justice is right in doing that or not, because they have some level of discretion to do it, but it's not completely unbounded. But the state court cannot compel the federal government to do this, so it would be an interesting fight. However, you can negotiate with the agency. You can agree to limit things and stuff like that. That we're only going to ask about this specific thing. Here are the questions we're going to ask, and the more narrow you make it, the more likely it is that they'll agree to let the person sit for the deposition. And since this is limited information he's asking for, that would certainly help in that process. Of course, one of the other things they look at is, well, how important is this case? Like, why do you really need us involved in it? And also, can't you just get this information from somebody else? So if the only information they want is that this letter was not written by the agent, and they're going to take Wood and Gore's deposition anyway, I could see the FBI saying, look, you've got other people who you think wrote this letter. Go ask them whether they wrote it or not. You don't need to be dragging us into it. Specifically, if the idea is the FBI is checking into this letter, and I'm dubious of that, but it could be true, then they're not going to want to have an agent set for a deposition on it because there's actually an ongoing investigation. And you can't subpoena the agent in the middle of an investigation and say, just tell me how your investigation is going. Give me all your information. They're going to say no to that, and the court, I think, it would back them up on it. So it'll be interesting to see how they navigate around that. But kind of like the Depp Heard case, if you're a law nerd, this case will begin, because of the resources of the people in it, will begin to involve people around different states and different issues and things, and bring some interesting legal arguments to light. So here we have out-of-state deponents, and how do you do that? It's not that hard. And then you want to depose an FBI agent on what you claim is an active investigation into a fraudulent document. That's a much touchier subject. Been showing some of the regulations involved in that. So I don't think that was mentioned in the arguments before the court yet. I don't know that it has to be, but it's certainly something that would be material. Still, to me, that agent's testimony is not critical, because you should be able to solicit that information from sources that you have, such as Wood and Gore, if the court approves that. But absolutely, Manson would want that FBI agent on the record saying, I've never seen this letter. I didn't sign this letter. I had nothing to do with this letter, because they want to pound that letter every chance they get, and I don't blame them for that. So we'll see soon, I suppose, when this motion for limited discovery is reset for hearing. And we'll find out what, if anything, the judge allows on that. And then the anti-SLAPP motions themselves will be heard sometime after that. There'll have to be some additional time given for those motions, because, as Manson's attorneys say, listen, if you give us this discovery, we have to go around the country to depose these people. We have to get these foreign subpoenas, these out-of-state subpoenas issued, domesticated in the state, and served on the people. And then those people, each one of them, have a right to resist that subpoena. And the federal government subpoena, that's essentially automatic by the regulations involved. But the other people can resist it too, depending on the nature of it and claiming it's burdensome or whatever. My point is, there's a process there that could take time. So Manson's attorneys are going to want a schedule that could include the maximum length of time that they may encounter in trying to get these depositions done, scheduling any kind of court hearings and things like that. It may go faster than that, but they need to have enough time to do what they want to do, or else what's the point of getting the discovery if you can't get it done before the hearing on the anti-SLAPP motions? So we will see how that turns out. And allegedly yesterday, Ashley Smithline was deposed, so there is discovery ongoing in the other cases. And when we get another update, we'll all look into it. Thanks, bye.